Buckle up, ladies and gentlemen. You are exiting the ordinary and entering the court gallery.
Thank you. Please raise your right hand. Do you solemnly swear or affirm the testimony you're about to give in this matter be the truth, the whole truth, and nothing but the truth?
Yes, I do.
All right, thank you. You may proceed on the warrant.
On February 18th, 2026, at approximately 3:43 in the morning, Officer Bro and Officer Sloan were dispatched to 10th Street for malicious destruction of property in progress. Officers were advised that a female was in the caller's backyard striking their vehicle with a baseball bat. Officers were then advised that the female fled in a gold-colored sedan, last seen northbound on Electric from Walnut. Officer Bro and Officer Sloan arrived at 2215 15th Street and spoke with the caller/witness, Jill Sotheby, Plano. She explained that she observed Becky Rose striking David Hasselback's 2017 Chevy Silverado with a baseball bat, causing damage to the hood, driver's side front and rear doors, driver's side rear fender, broke off the passenger side headlight, broke the driver's side door handle, and put multiple scrapes on the front driver's side window. Sotheby Polano further explained that she and Hasselback were sleeping when she woke up by a loud bang coming from the driveway. This is when she looked at the bedroom window and observed Rose striking Hasselback's vehicle. Rose was leaving the backyard to speak with Sotheby Polano, but when she realized she was on the phone with the police, she fled in her vehicle in an unknown direction. Hasselback explained to officers that he and Rose were in a former relationship and ended a few days ago, and this is probably the reason for her to damage his vehicle. Sotheby Polano has a camera facing a driveway and it captured the incident. Officer Saltzman responded to the call as well. He had prior knowledge of Rose and the vehicle that she drives. As Officer Saltzman was approaching Cedar and Electric Avenue, he observed an older gold Chevy Impala turn westbound onto Cedar Street from Cora Street. Officer Saltzman drove past the vehicle and observed a white female with brown hair sitting in the driver's seat as a sole occupant. At the same time, the caller told Officer Bro that the female left in a Dodge Neon. So Officer Saltzman disregarded the Chevy Impala and continued looking for a Dodge Neon. Moments later, Lincoln Park Police Officer Wilson, badge number 2634, Operating Patrol Unit 4A, advised they were attempting to catch up to a gold Chevy Impala with Michigan registration traveling northbound on 4th Street near Emmons. Officer Saltzman advised that this was the same vehicle that he just observed and he would like it stopped. Officer Wilson initiated traffic stop on the vehicle on 4th Street near Riverbank. Officer Saltzman made the scene and identified the driver in the vehicle as the same that he had seen near Cedar Street and Cora Street. The driver of the vehicle was identified as Rose, and she was taken into custody by Officer Saltzman for MDOP. During his interactions with Rose, Officer Saltzman observed her eyes to be bloodshot and glossy, and he also detected a strong odor of intoxicants coming from her person. So he requested her to submit to a standardized field sobriety test, which she did. After performing the FSTs, Officer Saltzman read Rose her preliminary breath test rights, which she agreed to submit to. Officer Saltzman administered a test and received a result of 0.34% BAC. He explained to Rose that she was under arrest for NDOP and OWI. While conducting an inventory search of the vehicle, Officer Smith located a wooden bat in the passenger seat of the vehicle. Officer Saltzman, while checking Rose's purse, located several containers containing pills. In a silver metal circular container, he located one white oval-shaped pill labeled M366. He identified this pill as a hydrocodone by utilizing drugs.com, which is a Schedule II controlled substance. Officer Saltzman read Rose her chemical test rights, and she agreed to a blood test. Rose was transported to the Henry Ford Wyandotte Hospital, where RN Nicholas Travis removed 2 vials of blood from her right arm. The vials were sealed and later placed in the outgoing mail to be mailed to the Michigan State Police Forensic Laboratories. Rose was transported back to the Wyandotte Police Station, where she was housed. After checking Rose through lien, it revealed that she had 2 prior OWI convictions. The first back in July of 2008 out of Southgate, and the second back in October of 2010 out of Woodhaven. A MAPS report was produced and it revealed that Rose had a prescription for hydrocodone 2025.
On examination of the complaining witness, I find that the offenses charged were committed. There's probable cause to believe defendant committed those offenses. And counsel, your appearance, please.
Good morning, Your Honor. Christopher Shemke, appearing on behalf of my client. This time we consent to the matter being heard via Zoom.
Thank you. And ma'am, your name for the record, please.
Michael Rose.
Okay. And counsel, as to the arraignment.
As the arraignment, we waive formal reading. My client stands mute.
The court will waive the formal reading. Ma'am, you do have the right to have an attorney. If you cannot afford one, you may have one appointed to represent you. And you did, in fact, have an opportunity to speak to an attorney today. Is that correct?
Yes.
The court has also signed the petition to order for appointed attorney for felony matters as well. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have a trial by a judge or by a jury, and you also have the right to remain silent. Anything you say orally or in writing may be used against you in court. Do you understand those rights?
Yes.
The court's going to enter a plea of not guilty on your behalf. Schedule this matter for probable cause conference on March 5th. 10:45 a.m. Counsel, as to bond.
Your Honor, I know that my client does have 2 priors, but I will note that they're both 15 years plus old. She's not on probation or parole. She lives in Lincoln Park with her daughter, who's 24, strong family support system. She works full-time at a nonprofit organization. Your Honor, I believe that this is obviously something that potentially stemmed from a breakup that went terribly wrong, but I don't believe this is inherent of a situation where she's going to duplicate this behavior. I don't believe that she's a flight risk. I would respectfully request any consideration, although it is a felony, that her 2 priors are significantly old, and the other one is regarding damage to property. I would ask consideration for a personal bond. Thank you, Judge.
All right, ma'am, where do you work?
I work for a nonprofit in Lincoln Park. It's a 501(c), the Downriver Alano Club. I also forgot to mention that I do crafts with my mom on the side as well. I didn't tell, I forgot to disclose that information.
Okay. And ma'am, if you were to test right now, what is in your system?
Only my prescription for my antidepressants, my anxiety meds that have been brought here and given to me by the officers.
Okay, and what do you do for the nonprofit, ma'am?
Counter help, help with events, cleaning, decorating, opening and making sure that the rooms are open for members.
And what is the use Alano or Alamo?
Alano, as a
Okay.
and as a no, sorry.
Okay, and that's an environment for individuals in recovery, correct?
Yes, it is. Something that, sorry.
And are you out on bond in any other jurisdiction?
No,
Have you ever failed to appear for court in any other matter?
ma'am. Mm-mm.
I'm sorry?
No, ma'am, I haven't.
All right.
I appeared when told to be or scheduled.
All right, and you're not on probation or parole anywhere, are you?
No, ma'am.
All right, Detective, would you like to address bond?
Yes, Your Honor. On this case, she does have 3 felony charges. Yes, the OWIs are older, but the MVP that she just committed, damaging the gentleman's car, I'm looking at 15,000, 10%.
All right. And ma'am, how do you know Mr. Hasselback? Do you have any children in common?
No, we were actually dating. We hadn't broken up. We had been together. And he didn't answer.
I would ask, Judge, they don't have any children together, and
Yeah.
they were in a relationship, or obviously there's going to be no contact provision, which I won't object to.
After review of the charges in this matter, review of Ms. Rose's criminal history, taking into account the nature of the charges and the allegations, and that there are 3 pending felonies, the court does not find a personal bond would be appropriate in this matter. The court does find that a bond of $20,000, 10%, is appropriate. You are not to, these are the following bond conditions, ma'am. You're not to have any contact with David Hasselback or Jill Sotheby Paulino. That's phone contact, text message, email, social media, third party, anything of the like. You are also not to enter the premises at Mr. Hasselback's home, nor Miss Sotheby Paulino's home. You're not to possess or consume any alcohol or drugs unless prescribed. You also, ma'am, are not even to be on the streets that they reside on. You don't reside in Wyandotte. You don't have any reason to be on those streets. You're not to possess or have access to firearms or weapons. Do you have any of those, ma'am?
No.
You are not to be released without GPS and alcohol tether through the Wayne County Jail. Any questions?
No.
Okay, we'll see you back on March 5th. Thank you.
Thank you, Judge.
You can go in there and you can come over here. You got anything on the zone here? Yep. That was
4? This lady has 4?
Yeah, she had warrants off, and then.
Okay.
You guys
All right, let's go on the record in the matters of, let's see, we have the City of Wyandotte versus Cheryl Shabani, 1829227. 193794. The State of Michigan versus Cheryl Shabani, 241258. And the City of Wyandotte versus Cheryl Shabani, 26208. Okay, counsel?
Good morning, Your Honor. Christopher Shemke, appearing on behalf of my client. This time we consent to the matter being heard via Zoom.
Ma'am, your name for the record, please.
Cheryl Shabani?
All right, counsel, as the City of Wyandotte matters, which there are 3 of those, I'm actually running out of room on here with all of these files. With the City of Wyandotte matters, counsel, let's handle those as far as an arraignment. As the arraignment on those matters, counsel.
When we wait formal reading, my client stands mute.
Okay, the court will waive the formal reading on those matters. Enter pleas of not guilty on your client's behalf. Schedule these matters for pretrial on March 4th, 10:45 a.m.
I didn't like that one.
And then counsel, as to the state matter.
We wait formal reading, my client stands mute.
All right, ma'am, the court's going to waive the formal reading in that matter. You do understand you do have the right to have an attorney. And if you're unable to afford an attorney, you may have one appointed to represent you. Do you understand that, ma'am?
Yes, ma'am.
You have in fact had an opportunity to speak to an attorney today. Is that correct?
Yes, I did just before this.
The court is also signing the petition order for appointed attorney for felony matters as well. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have a trial by a judge or by a jury. And you also have the right to remain silent. Anything you say orally or in writing may be used against you in court. Do you understand those rights, ma'am?
Yes, ma'am.
The court will enter a plea of not guilty on your behalf. Schedule this matter for probable cause conference on March 5th
10:45.
at 10:45 a.m. also.
It's 2 days right next to each other.
What's that, ma'am?
Nothing.
Okay, counsel, as to bond.
Your Honor, on a positive note, my client is a local resident of Lincoln Park, currently lives alone, but she is gainfully employed. She works at Getwell Urgent Care in Southgate. She's a medical assistant. She's also a full-time student at Henry Ford, taking 13 credits, and she has aspirations to go to nursing school. Judge, I know that there's some outstanding warrants. We'd ask that those be set aside, and we'd ask any leniency with determining an appropriate bond based on her age, her employment, and her schooling. Thank you, Judge.
All right, ma'am, why do you continue to ghost the court here? Do you not like to come visit here?
The last court date I did come to, the first one, apparently I thought it was a video on my phone, but it wasn't, it was here. But then my attorney rescheduled that next one. And then when I showed up to that one, I sat there for 2.5 hours on the video one. My attorney never showed up. And then I was told to hang up and get a hold of her. I got a hold of her. She never got a hold of me back. Now that's
Hold
on
on.
me. I should have called again. I should have rescheduled.
Well, of course, ma'am, because it's been 16 months. So actually almost 18 months. So yes, well, first of all, you were arraigned out county on your felony matter September 1st of 24. You were scheduled for a probable cause conference September 12th. You did not show up. A warrant was issued for your arrest. Prior to the court issuing the warrant, you must have contacted in and we rescheduled it to September 26th.
Yeah.
You were present. Your attorney was not.
Yes, ma'am.
The court made a note on here that you were present, but not at the time the case was called. Defense attorney attempted contact to no avail. The court waited an additional 2 hours to call the case so that your attorney could get a hold of you. And he or she was unable, Sarah Krause, she was unable to get in touch with you. And so the court issued an immediate warrant. Now, it's important to note that your charge in this matter is possession of controlled substance and driving a license suspended, revoked, or denied. That's important, ma'am, because not only did you fail to appear on 2 other matters for the same charge of driving a license suspended, revoked, or denied, but then you ended up arrested last night for the exact same thing once again.
Yes,
And
ma'am.
you have made zero attempt to contact into the court to schedule any court dates. Because you also, ma'am, on your 2019 and 2018 cases also had failed to appear for your arraignment pretrials. We ended up sending you notice. We sent it for October 30th of 24. And you once again failed to appear in court on October 30th of 2024. You did not contact the court. You did zero, ma'am, to resolve your issues. Zero.
On the first ones, yes, ma'am, you're right. I didn't. I was very immature. Even though I was an adult, but I was very immature and stupid. I had a lot of drug problems. I've been trying to work through that stuff now. I haven't used drugs in a very, very long time now. I'm trying to get a better education. And that last one we got before this one with the drugs, I want to fight that one. And I was trying to fight it. And I'm sorry I didn't push it further and keep trying my lawyer. I want
Ma'am?
to take care of this and get this out of the way. I don't want
Ma'am?
this to have more.
Ma'am, I can appreciate and commend you for being in recovery. However, what I'm hearing from you is you want to take care of these matters, but you're not doing anything to take care of them.
I do want to take care of them.
Excuse me, you're continuing to violate the law and driving without a valid license, as you're alleged in all 4 cases to continue to be doing.
I lost my license for the driver's responsibility fee. I didn't even know that was a thing until after I lost my license. So yes, I got upset. Wasn't fair. I lose my license for something I didn't even know about.
Well, ma'am, then you have to address it. You have to,
Dumb.
excuse me. You need to address it and you need to stop driving until it's addressed.
Yes, ma'am.
And you reside by yourself?
Yes, ma'am.
All right. And you know, and you knew that you had warrants, and you knew your license was suspended, and you continued to drive anyway.
Yes, ma'am.
The court's going to, on the 24 matter, the court's going to order a $10,000, 10% bond. Based upon your previous failures to appear, the matter, you have three matters that you failed to appear on, and then you have a new matter that's the same charge as the other three matters.
That's 4 or 5 of them.
And the court will note that you have not made any attempt to resolve these matters since September of 24. The court's going to order on the 26th case a $10,000, 10% bond. The court wants to ensure the safety of the public as well, because you continue to operate a motor vehicle without a valid license, which does put the community at risk. On the 193794, the court's going to order a $5,000, 10% bond. And on the 182927, the court's going to order a $5,000, 10% bond. Your bond conditions, ma'am, are that you're not to possess or consume any alcohol or drugs that are not prescribed, and that you are to not operate a motor vehicle without a valid driver's license, which you're not allowed to do anyway, ma'am. But if you are, if you've posted bond and you are out and about and you're driving a motor vehicle, ma'am, you will be arrested again, and the court will likely revoke bond. And you'll be in custody until your next court date.
Understood, ma'am.
Have a good day.
Thank you, Your Honor.
All right, off the record.
Mr. Dakota Cat.
Yes, sir. I know Mr. Cat.
Good morning.
Good morning. All right. Your Honor. Good morning. This is State of Florida versus Dakota Cat, 25 CF 2340. And I think also has 24 CF 3049, which is should be a violation of probation. We're here today on a motion to suppress. And Mr. Cat is, Mr. Ballock's filed on behalf of Mr. Cat, and the state has responded. Thank you. All right. You too, Mr. Meredith. Thank you. Ms. Beasley, you have a good weekend too. All right. All right, see, this is, the state concede they have the verdict?
Yes.
Okay.
State called John Gay.
Mr. Gay, come on up.
Yes, ma'am.
Good morning. Say your name for the record, please.
John Darby Gay Jr.,
And where do you work?
the Panama City Police Department,
How long have you worked there?
since May 2023.
What are your current duties?
I'm a detective with the Street Crimes Unit,
How long have you been in street crimes?
approximately a year.
What's the role of the street crimes unit?
Mostly narcotics, drugs, prostitution, vice crimes, etc.
So you're part of the drug unit for the city?
Yes, sir.
As part of your training, are you trained to detect the odor of marijuana?
Yes, sir.
Were you working on July the 29th, 2025?
Yes, sir.
Right now, you arrived there and were you involved in a different arrest, 261 Everett Avenue?
Yes, sir.
And that's the Henry Clerkman Apartments?
Yes, sir.
Now, about that area, have you in your experience done drug arrests in that apartment complex before?
Absolutely.
All right, so would you consider that a high crime area and specifically about narcotics?
I would.
Now, so you're involved in this other arrest of someone else. How did you first come into contact with the defendant, Dakota Cat?
We were currently investigating another drug offense in the parking lot of Henry Kirkland. While talking to him, Dakota Cat exited an apartment nearby. As soon as he saw us, he started making furtive movements, tucking stuff in his pants, and he walked right beside us. His person smelled of marijuana. We made contact with him at his vehicle, and obviously his vehicle.
Yeah, we'll get there. So he walks by you. How does he look?
Nervous.
He looks nervous. And then he goes, where does he go?
Straight to his vehicle.
And what do you do?
Well, I made contact with him at his vehicle.
All right, and what happened when you approached the vehicle?
As myself and Detective Shaver were approaching his vehicle, he tried to rapidly start it and leave. But we exited our vehicle, made contact with him at his driver door. I tried to ask him to get out of the car. His car smelled like marijuana. He instantly began resisting, wouldn't let go of the steering wheel. We had to force him out of his vehicle.
Now, by the time that he got into the car, did you see him doing anything in the car?
Yes, sir. He would, when he sat in his car as we were making contact with him, he was also still trying to mess with his pants, just sticking stuff in his pants.
And did that cause you any concerns?
Yes, sir. It's a big officer safety concern, possibly destruction of evidence or concealing evidence, etc.
So two concerns there, of potential for officer safety and potential of destruction of evidence.
Yes, sir.
And you asked him to get out of the car?
Yes, sir.
Were you wearing your police gear?
I was.
So you were clearly marked as a police officer?
Yes, sir.
And he didn't comply with any of your orders to get out of the car. You had to physically remove him from the vehicle.
Correct.
Did you search the defendant?
Yes, sir.
Did you find something?
Yes, sir.
What'd you find?
He had a $20 bill that was folded multiple times. It had a substance inside of it that field tested positive for fentanyl.
And in your experience, that fold, is that indicative of anything?
Yes, sir. It's common with street level narcotics.
So you had a substance tested positive for fentanyl?
Yes, sir.
Did you then search the car?
Yes, sir.
What'd you find in the car?
Ammunition and marijuana.
And you then found out that Mr. Cat is a convicted felon?
Correct.
And we're not allowed to have that ammunition?
Correct.
No further questions?
About your witness.
Okay, you said that you were investigating a separate issue at this time, correct?
Correct.
How long were you on scene for that?
20 minutes.
Okay. And was that at all related to Mr. Cat?
Yes, sir.
That investigation was related to Mr. Cat?
Yes, sir.
How's that?
What we were investigating is we got out with somebody in the parking lot of Henry Kirkland Apartments, had fentanyl paraphernalia in plain view inside his vehicle. That individual later provided a sworn recorded statement that Dakota Cat did sell him the fentanyl from his apartment. And Dakota Cat was later interviewed at the Panama City Police Department in reference to that.
This all happened after this encounter though, right?
No.
This happened prior to?
Yes.
How soon before?
Minutes.
So minutes before they gave a sworn statement that Mr. Cat was involved.
Correct.
And that's an investigative report that you
Not mine, the corporal porter.
reporter?
Corporal
Corporal.
porter, P-O-R-T-E-R.
So you said that it smelt like weed. How close did you get to Mr. Cat?
When he walked by us.
Yeah.
Feet.
And what type of day was it? Was it dark out? Was it
It
light?
was clear sunny skies, 5 o'clock in the afternoon.
Okay. Was it windy?
Not very.
You said in your report that you smelled burnt marijuana, or was it regular marijuana odor?
Marijuana.
Is there a difference between burnt or regular?
To some people.
What about to you?
Not really.
Did you smell burnt or regular marijuana?
I smelled marijuana.
Okay. Was there any?
I want to know, is it burnt or green marijuana? I mean, that's a question I'd like to put in the staff answer.
Burnt.
Okay. Was there any indicators that would suggest that there was marijuana being burnt? Was there any smoke coming off this person?
While he was walking, no, sir.
Okay. Was he holding a joint or a blunt?
No, sir.
Did he toss anything in your presence?
No, sir, but he was messing with his pants.
Okay. Is that in itself criminal?
What?
Criminal in nature to tuck in his shirt or put things in his pockets?
Yeah, it can be, yes.
Okay. So it could be innocent, but in this situation, you saw it as criminal.
Let's hold on just a second. Whoever's out there making the noise, y'all need to be quiet. If you can't be quiet, leave the courtroom.
I think I was saying that you didn't see any observable evidence to suggest that he had a burning piece of marijuana on his person, right?
Correct.
Okay, so all you smelt was what you thought was an odor coming from his person.
Correct.
Okay. You don't stop him right then though, right?
No, sir.
Okay, you get in your car and you drive to his car, right?
Correct.
He's in his car when you pull out and you block him in, right?
Correct.
So he was unable to move.
Correct.
Was there any indicators that the car was turned on?
Well,
Did the lights illuminate in Mr. Catt's car?
No, I could hear the ignition.
Was it a push to start or a key turn?
It was a key.
Okay, so you're in your car driving up and you can hear the car starting.
No, sir. It started when we exited our vehicle.
Okay, so you exit the vehicle and you're approaching his car.
Correct.
And you're saying that he tried to start the car then?
Correct.
Was he under arrest at that point?
No, he was detained at that point, or preparing to be detained.
Did you give any lawful orders prior to that?
Prior to
pulling up?
No,
As he passed you, did you say, hey, stop?
No, sir. I didn't make contact with him until I pulled up to him.
Okay, so he passes by you, he puts something in his pocket, he tucks his shirt in, and you see that as indicators of criminal activity?
Yes, sir.
You walk up and within 6 seconds, you get him out of the car, right?
I don't know how long it took.
Did he open the car or did you open the car door?
I did.
So you walk up after blocking him in and immediately order him out and open the car door.
Correct.
Did you give him any chance to comply?
Yes, sir.
Did you say open the door?
I said step out of the car, open the door, and then myself and Detective Shaver ordered him multiple times to step out of the vehicle, to which he did not.
At this point, does he have to turn the car off?
No.
Because it's not on.
What do you mean?
The car at this point is not on, right?
No, he couldn't start it. The ignition was just turning.
Okay. And you saw that as evidence of him trying to flee?
Trying to not follow orders, yes, sir.
Okay, but at this point, he doesn't even know that he's being arrested or detained or anything, right?
No, he did. He was being told.
Through the glass in the car?
Oh, the door was open.
Okay. So it's your position that he was fleeing by trying to start the car?
I didn't say that he was fleeing.
So he was never fleeing?
No, sir.
Did you find any marijuana on his person when you did search him?
No, sir.
And when you did field test the remnants or the residue on the dollar bill, you said it came back to be fentanyl?
Yes, sir.
And was it later lab tested?
I believe so.
And did it come back not fentanyl?
I did not get the results for those. It wasn't.
If I were to show you, could you confirm it was or wasn't?
No controlled substance.
So what you presume to be criminal activity later was understood to not be, right?
I don't fully disagree with that or wholly agree with that.
Felt like marijuana, but you found no marijuana in his person, correct?
No, sir, just in his vehicle.
And then what you thought was fentanyl on his person ended up not being fentanyl, correct?
Correct.
Would you agree that positioning your car in front of his made it impossible for him to be evasive or to flee?
Yes.
Did you ever ask him if he had a med card?
No, sir.
And where was the marijuana found in the car?
In the rear seat of his vehicle,
Okay, so not in the front seat or the passenger seat.
in the rear seat.
Okay, was it in a box or anything?
No, sir, it's just a joint.
Was it already lit?
It had been burnt previously.
How far would you say that you traveled from where your car was parked to get to where Mr. Cat was?
25, 30 yards.
I told you it took you 16 seconds to get there. Would that be somewhat accurate?
Sure.
Okay. So it takes you 16 seconds to get to his car. And that you're saying that all the while driving over there, you were able to see through your glass and his glass, him doing movements in the car?
Yes, sir.
Your view wasn't obstructed at all?
No, sir.
Did Mr. Cat ever ask you why he was being stopped?
Yeah, multiple times. I told him that he was being detained for a lawful reason.
And what was that reason?
The odor of marijuana and the sworn statement collected from the individual.
I don't think I have any further questions for him, Your Honor.
Any redirect?
Yeah, just briefly, there was ammunition in his vehicle.
Correct.
And he was placed under arrest for being a felon in possession of ammunition.
Yes, sir.
Any other questions?
No.
Can the witness be excused?
Yes, sir.
Sir, you may go about your day.
Thanks, sir.
Call your next witness.
That's all I have, Your Honor.
All right. Anything else?
Just like to add some closing argument, Your Honor.
Sure.
It's the state's position, there's the defense's position that the state has mischaracterized this as a detention that escalated. And it's our position that it was a detention from the start that's unsupported by objective facts, and the state attempts to justify it with facts learned afterwards. I believe that they cite several cases as controlling in this case. The first one is Mims, and we believe that the facts in this are distinguishable from Mims because in Mims, it's a Supreme Court decision where the defendant was driving erratic, or he was driving on an expired tag. They pulled him over, they asked him to come out, and they had lawful reason to do so because he was being detained for breaking the law. This is distinguishable here because Mr. Cat was not driving. He was not breaking the law in any way. There are weak facts that the state stacks to make it seem like there's a stronger, compelling argument for why the justification was for detaining him. But it's our position that those weak facts don't automatically become strong facts just because you have a lot of them. It's our position that when taking the totality of the circumstance, the furtive movements are tucking in his shirt and putting his hands in his pockets, moving his hands around in the car. He could have been using his cell phone, generic nervousness, and then vague officer conclusions. We don't believe that that's taking this in the totality of the circumstances, create objective facts to prove that unlawful activity was taking place. And to go even further, the state then cites the first DCA opinion from Hatcher. This is distinguishable from that case as well, because in that case, the defendant was driving at 3 a.m. He was driving erratically. When he gets pulled over, he admits, I just smoked a blunt, I just threw it out. He makes admissions, and then it's later determined that he was at a no valid driver's license. So they had the basis to determine that the detention was lawful based on objective, articulable facts in the case. In this case, He wasn't driving. He wasn't acting erratically. And the officer even admitted that the basis for it was not that he was fleeing or eluding, as the state contends in their response to our position. It's the state's position that we mischaracterized this stop as it beginning when the odor was detected, and that the stop actually happened when he was trying to flee. But it's the officer's position that he was never trying to flee. The officer put his car in a position where it was impossible for Mr. Cat to flee. And then there's no objectable facts to prove that he was doing anything unlawful aside from just smelling like marijuana. And I mean, we're talking about an open area in the middle of the day in a known crime area where they're saying that it came from him and not from somewhere else in the area. I think that those are weak arguments. We also rely on Kilburn, where it's another DCA opinion, their first DCA opinion. In that case, the court found that innocent behavior, in that case, the facts are that there was a gun in plain view, that they said that's an unlawful activity. But the court determined, no, that's actually not unlawful and not criminal activity, because you can have a legal gun, and just seeing the gun is not evidence of criminal activity. In this case, we argue that the weed smell alone is akin to the observation of a firearm in the vehicle. That just because it smells like marijuana doesn't mean that he's committing an unlawful act. They never asked if he had a med card. They never asked if he was in lawful possession of marijuana. They just assumed that because he was in a high crime area, that he somewhat smelled like marijuana, even though he testified wasn't burnt marijuana, it was the odor of marijuana, that does not justify breaking his Fourth Amendment by protections. It's our contention that the basis for the stop was for the smell of marijuana and not for fleeing. There was no lawful detainer. He was never told that he was under arrest. And moreover, Your Honor, I'll just write down. It's our position that that there was no lawful stop here, that MIMS, that was reference to them, it presupposes that a lawful detention was taken, had occurred, and that the issue here is that there's no basis for the detention of the defendant. And then Hatcher, it shows independent facts that created an issue before there was an escalation. We believe that the state, that the officers in this case escalated this situation, and that here it is. We believe that, Your Honor, because there was no marijuana on this person, and because the fentanyl tested, the suspected fentanyl ended up not being a controlled substance, it's our position that the state is in the wrong for continuing to prosecute Mr. Cat, and that rather than admitting it, we now have to prove why this whole thing never should have happened the way it did. Your Honor, it's our position that Mr. Cat was acting lawfully on this date, and that he was detained without objective facts to establish he was creating or doing anything unlawful, and the officer is unable to articulate a valid reason to detain him. It was the state's position said, no, actually he wasn't. On just the smell of marijuana, I believe that they're violating his protections by using that as the sole basis to detain him and then further search.
Yes, Your Honor. A few things. I think Mr. Ballack suffers from a case of selective amnesia, starting with the fact that he puts in footnote number 1 of his motion that he accepts all of the facts of the state as undisputed, but then comes here and wants to challenge all of the facts. So I'm not sure if he wants to have his cake graded too, if the facts of the state's alleging are undisputed, and then he comes in here and challenges those facts. So one way or another. He's also missing one of the things that he elicited today, which I had not written in my response, but there was an informant who pointed directly to Mr. Cat as the person who had sold him the fentanyl. So it's not just the basis of marijuana alone. Mr. Ballack seems to forget that they had information about Mr. Cat selling fentanyl. They find a substance that field tests positive for fentanyl. It doesn't matter that it later wasn't anything. And I'm not prosecuting him for the possession of fentanyl anymore. We're prosecuting him for being a felon in possession of ammunition. So the later field test or the later test doesn't matter at this point. What matters is they were justified at that point in time because they had the field test, which allowed them to search the car and find the ammunition. We had an encounter here that was escalated over time. So, and each of the steps, they were allowed to do what they did, right? So they were allowed to approach him the way that they did because they had information about him and his appearance and his furtive movements. There's been no testimony about tucking in a shirt. I don't care how many times Mr. Ballack has to say that, right? He's the one who's saying he was tucking in his shirt. And then in the car, those furtive movements, and that allowed him to ask him to get out of the car. They search him, then he refuses, which then puts him under arrest at that point and being detained. The search of his person yields the fentanyl, which allows him to get into the car. So at each of the steps here, law enforcement followed what needed to occur. And again, missing and forgetting about certain inconvenient facts doesn't make it so.
I'll take it under advisement. We'll set this, no, we're not set for trial.
I like to set this for an evidentiary hearing. That's where this will end up.
Yeah,
Yes.
let's set it for March 25th at 1:30 and 9 o'clock. Now I have an order on this motion to suppress prior to that. Okay?
May I point out something that's really,
Unless you want to be placed under oath and be subject to cross-examination, no, sir. Mr. Cat, just have a seat. You weren't called as a witness. You want to be called, if your attorney wanted to call you as a witness, you'd have to be sworn and give testimony. So have a
ma'am,
seat.
you can leave. Now I'm talking about her. You need to leave right now.
Your Honor, if we could just reopen it.
Both y'all can leave.
Opportunity.
You might want to talk to him. I mean, because he's going to be subject to cross-examination and everything else. Mr. Cat, just have a seat.
Yes, sir.
All right, you call your next case.
The only other one I have is with Mr. Solomon. We're waiting for him to get back from sentencing.
Which one is that?
Foster.
What are we doing on Foster? What is that?
Well, I understand, but Mr. Sullivan was hopeful he would be here.
Florida Anthony Foster, 25 CF 3217. We're here today on the Mr. Foster's motion to suppress. Doc, you ready to proceed? Mr. Sullivan, you ready to proceed? You concede that you have the burden?
Yes. Call Officer Casey.
Yes. Tyler Casey,
Where are you employed?
Panama City.
How long have you been with Panama City?
It'll be 4 years this year.
And you are a K-9 officer?
Yes.
Your K-9 is Molly?
Yes.
How long have you been an officer with Molly?
I got her in September.
September 2025?
Yes.
What type of training do you have to go through in order to become a K-9 officer?
We did a 6-week training with the K-9 trainer.
And is Molly certified?
Yeah, we were certified through NNDDA.
What is that?
It's the National Narcotic Detection Dog Association.
As part of your K-9 handler duties, do you have to undergo regular training with Molly?
Yes.
How often do you do that?
We're required to do 16 hours a month of training, but we go above and beyond that usually.
Can you estimate about how much time you spend with Molly on training?
Every time I'm on shift, we do at least an hour of obedience, and then past that, we'll do about an hour of narcotic training, and then she's also certified in bite work, so we do that as well.
What drugs are Molly trained to detect?
She's trained on fentanyl, methamphetamine, heroin, crack, and cocaine.
I want to talk a little bit about Molly's process of locating drugs. I
I guess we'll do it this way. Were you asked to conduct a sniff with Molly on the vehicle that Mr. Foster was in?
Yes.
And that was in October of 2025?
Yes.
Could you walk the court through your process with Molly and why you do what you do when you arrive on scene?
Yes. So when I get there, ask the officer basically what they've got, what we're doing. And they usually just tell me, hey, we just need a free air sniff. So I will take the dog out, go to the, I always start in the same spot, the driver's side front area bumper, and we go around the vehicle. And then if she shows any behavior changes or anything like that, or hasn't shown an alert, we do another pass around.
Okay. So I want to distinguish between behavior changes and alert. For you, are those two different things?
Yes.
Okay. What do you mean by alert?
So an alert, a final alert would be her sitting at an odor.
And what is Molly trained to, I guess, alert on?
Those 5 narcotics that I listed earlier.
That was a poor question. I mean,
Okay.
so you distinguish between behavior changes and alert.
Yes.
At what point does Molly get where she gives an alert?
She's been trained to perform the task, and then if she finds an odor, she will alert,
Okay.
or she is trained to alert.
Okay. And what is her alert?
To sit.
In this particular case, did Molly give you that indication by sitting?
No.
Now, let's talk about behavior changes.
Mhm.
What are you looking for as far as behavior changes go?
Once I give her the command to search, I will watch her and look for her to close her mouth to sniff deeply. I'll look for her to have a head snapped, which is where she basically almost turns back around with her head. Look for pauses as we're walking around the vehicle. Any behavior change that's not normal from what we've trained.
Okay. And were there behavior changes in this particular case?
Yes.
What behavior changes did you observe, and where did they occur in your process of walking her around?
All of the behavior changes occurred at the driver's side door.
Okay.
She had a head snap as we passed it the first time. She closed her mouth and took quick, heavy sniffs. When we came back the second time, she stayed in the odor, so she stayed right there. She never sat, but she would not keep moving the car, even if I was moving.
Okay. And what did that tell you as her handler?
She's in an odor of a narcotic odor she's trained on.
Okay. How do you reconcile that with the fact that she didn't give a final alert?
It would be all the behavior changes, not just one or altogether. The totality of them would be an alert to a handler.
And is that what you observed in this particular case?
Yes.
And based on that, was the vehicle ultimately searched?
Yes.
I've got no further questions, John.
Well, yes, sir.
Just to be clear, Officer Casey, during the arrest on 1010, K9 Molly never sat.
Correct.
And I noticed that you said that you got her September 2025. When was she actually certified?
She was certified in narcotics in September. I don't know the exact date.
So within a month, you get her and she's certified.
Yeah, we certified within the first week, and then we certified the rest of it about 4 weeks later.
Okay. So this incident took place less than a month after she was certified.
Correct.
Was she on or off the leash when you were doing this?
On leash.
She was on the leash, and she's trained to be on the leash. She's certified for on the leash?
Yes.
Okay. I have here some of your training reports. Looks like you did ones on the 4th, the 8th, the 17th, the 9th of September, the 23rd of September, all the way up until a few days before. Do you remember doing these reports?
Yes.
Okay. And these are for the training of Molly, correct?
Correct.
Do you remember making a report where on September 4th, you stated that Molly was investigating the deaths, she sniffed the top and indicated there was an odor.
If I wrote it, then, but I don't remember it exactly.
And then you would say when she found the source, she alerted by sitting.
Correct.
Okay. So she's rewarded for alerting, correct?
Correct.
And she's not rewarded for indicating.
It depends on the training we're doing. Sometimes we reward her for the behavior changes.
You didn't reward her changing in behavior on September 4th, right?
If that's what the report says.
But you did reward her for sitting, correct?
Correct.
We'll have you back at 1:30, okay? Go ahead. I'm sorry, Mr. Ballard.
So that was September 4th. You did not reward her for indicating, but you did for sitting, correct?
Correct.
On September 8th, you noted that during your training on the 8th at 5:30, I'll skip to the relevant portion. Molly had her head snapped back, indicating an interest in an odor, and there was no reward for that, correct?
Correct.
And then later, she began inspecting that area by taking quick, heavy sniffs. When she found the source, she alerted by sitting and was rewarded, correct?
Correct.
And then you note in that report that she alerted by sitting, and was rewarded every time, correct?
Correct.
On September 9th, the next day in the morning, you were searching for fentanyl and not give a final alert, but then she was corrected. And when she sat, she was rewarded. Do you remember giving that report?
Correct.
On the 17th, you noted 6 times that she alerted and she was rewarded. Do you remember those?
Yes.
Okay. And at no point was she ever rewarded on that day for indicating.
All of the indications had behavior changes associated with them.
Right. But it goes in your training, it goes indicators that lead to an alert, correct?
Correct.
On the 18th, you had similar findings where there was indications without rewards, and then when she was alerted by sitting, she was rewarded. Do you remember that?
Yes.
In the same day, later on that day, you made reports that sitting was a final alert. Do you remember that in rewarding her?
Yes.
In it, other points you make references to final alerts being when she sits, correct?
Correct.
At no point is a final alert or an alert in general characterized as doing the behavioral changes, correct?
In my reports, yes.
On the 19th, you made a note in your training report that you conducted a simulated traffic stop. She sniffed every scene in the car, but would not give a final alert by sitting. You then directed her to sniff where you knew she did. That's when she sat and was rewarded.
Correct.
So she was not rewarded just for going around the car, sniffing every scene in the car. She's only rewarded when she gives an alert or a final alert for sitting.
Correct.
Again, on September 23rd, you indicated that Molly indicated an odor. She was never rewarded, but then later when she found the source, she alerted by sitting. And then later in that report, you say that on 3 blank vehicles, she never alerted or showed any changes in behavior, changes indicating an odor. Do you remember giving that report?
Yes.
So what specifically did Molly do on 10/10/25 that would lead you to believe that she was alerting to the vehicle?
As I stated before, she had a head snap. She closed her mouth and took quick, heavy sniffs at the driver's side door. And then as we came back the last time, she stayed in the spot and would not move.
Do And based on the testimony in reference to your training reports, she was never rewarded for any of those actions during the training while she was in your care, correct?
She was rewarded at the alert, but she had all those indicators leading up to the alert and was rewarded for all of that.
Correct. But I'm asking, at no point in any of her training was she ever rewarded for head snapping, closing her mouth, or staying in a place for too
She
long?
was rewarded for that, as well as the sit.
On what day did that happen? I just ran through.
You ran through all of them, and she was rewarded at the sit, but she was rewarded for all the indicators leading up to the sit.
There was also times when she would not, and you didn't reward her.
Correct, because we're training at a known source.
Should Molly behave as she's trained to do in the field, or does she have free will to do anything she wants in the field?
She should behave as she's trained, yes.
Is it your belief that sitting provides probable cause to then search the car? An alert provides probable cause?
Yes.
Any further questions?
Yes, I know this is gonna sound like a stupid question, but when you run your dog can't just speak up and tell you, hey, I smell drugs, can it?
Correct.
So when you do your training, you're training the dog in a way to communicate to you that it smells drugs.
Yes.
Correct? But as a canine handler, you're able to watch and observe these behavior changes that also indicate, short of that communication, that the dog smells drugs.
Yes.
And in this particular case, drugs were also found in the vehicle based off of the search that was conducted.
Correct. 110 grams.
So the dog's senses in this particular case were accurate.
Yes.
Your observation of the dog's behavior changes were accurate.
Yes.
Have you taken your dog and run the dog before and not noticed any of these behavior changes?
Yes.
No further questions, John.
Any other questions?
Are you a dog whisperer?
No.
Anything else for this witness?
No, Your Honor.
He be excused.
Yes, Your Honor.
Or you may go about your day. Any other witnesses?
No, Your Honor.
Any argument?
Yes, Your Honor. The fact that he's not a dog whisperer is exactly why he watches and observes the behavior changes. I'd also, just as far as argument goes, Judge, this is the exact same issue that Mr. Valak asked you to reconsider in the Maurice Bennett case yesterday. So as far as the case law goes, Your Honor's already done the research, knows the law. I would ask that you just essentially repurpose that order because it's the exact same situation as this case.
Anything else?
Yes, Your Honor, I would contend that it is the exact same situation. And in your analysis, you note that, I believe it was the Prada argument, that you explained that there are indicators that lead to an alert. Or no, there's alerts that lead to an indicator that it indicates where the presence of the narcotics are found. However, in the training logs, it does the reverse logic. It says that it needs indicators to get to the alert. At no point in the training logs is he ever rewarded for changes in behaviors. He was never rewarded for a head snap. He was never rewarded for a closed mouth or staying for too long. The question is, did the canine alert the officer? And if he did alert it, that provides probable cause. It's our contention that an alert is a term of art. It's not alerting, alerted. It's not an interchangeable word. The officer only gets probable cause when the dog comes out and alerts the officers to the presence of narcotics potentially being in the vehicle. I agree that the state's trying to use the dog whisperer argument against me, but how do we know what the dog is trying to convey if it doesn't do what it was trained to do? The officer, Casey, handled the canine around the vehicle multiple times and had every opportunity to provide the officer with probable cause by sitting, and it never did that. It's undisputed that Molly never sat. If the dog doesn't sit, then the dog does not objectively alert the officer to the presence of narcotics. The Prada argument is that the dog is always alerting. It's alerting by changing behavior and that it indicates the presence of narcotics. But the training logs say the opposite. It says that it indicates a potential odor of narcotics through changes in behavior, but it never alerts until it sits. So unless the dog sat, it never provided the probable cause.
Very good. All right, I'll take it under advisement. Where are we at as far as the case?
Remember, we could put the training logs in the vault list,
What?
the vault list.
In the evidence? Any objection? They'll be marked as defendant's exhibit number 1.
Question for the, where we're at posturally in the case. I believe we've already done depositions. We'd asked if you did find a motion, and then we discussed entering a plea. And
What I said, March 26th. Is that our motion? That's our pretrial at 9 o'clock. No, the motion, I have a water copy.
thank you.
All right, thank y'all. All right. That's all we've got this morning. We've got just, Alistair, we got a couple this afternoon. Is Mr. Overstreet gonna be here or somebody covering for him? All right.
Thank you.
Yes, sir, Mr. Ballard. Have a good weekend.
Thank you. Court calls case, people versus Kyler Johnson versus Amadalen Bailey.
Ready, Your Honor. Dawn Van Dusen, P69647 on behalf of plaintiff.
Judge Dominic Camden, P67745, appearing on behalf of the defendant, Amanda Lynn Bailey. Judge, my client is also in the Zoom room.
Oh, there she is. All right. All right, where are we on this case, folks?
Your Honor, this matter that it's regarding a trailer park, a mobile home in that park. My client, which is Kyler Johnson, owns the trailer in the park. Miss Bailey is his ex-girlfriend who is occupying it at this time. At this time, they did do a purchase agreement at one point, but I think I don't know where they got their purchase agreement, but Mr. Johnson would like to, already told her that he was going to rescind it. He does not live there at this time, but he would like the occupancy to happen. He has a loan payment on this trailer each month that has never, it was agreed that she'd split half of it. She still hasn't made any of that. She failed to make payments October all the way to February on just that loan, which is her portion would be 500 of it. But with them not being together, it's a total of 1,000. The rent there on the lot,
because they're not together, her payment went up.
well, they agreed they would split it at one point, but she hasn't made any of it. So we're not even asking for a judgment in this matter. We just want, as in a money judgment, we'd just like Miss Bailey to move out of the home, out of the trailer. She's changed the utilities into his name, into her own name. She has, so he cannot even get access to make sure payments are made. So she's actually only made payments starting in January for the utilities. So we're asking at this time that eviction of a 10-day order be granted to order her out of the premises.
Mr. Hamden.
Judge, the parties are subject to a purchase agreement. I don't believe you can just unilaterally rescind an agreement. I don't believe the purchase agreement provides for that. And my client is still wishing and desiring to go forward with that purchase. Second of all, my client is on the written lease agreement with the park. And so she has the right to occupy this space as the landlord to the property. So this is probably better characterized, Judge, as some form of a replevin case, as opposed to an eviction in order to retain his property back. It's not properly characterized as an eviction. It's probably better characterized as some form of a replevin.
Well, but I don't. Is the purchase agreement still in effect?
It did not have a termination date, Judge.
Your Honor, it also says the initial payment is non-refundable. It looks like she received this piece of purchase agreement, a copy of it, and that she filled it out, and it was part of the the parks, where if they were going to sell you one of their trailers. I mean, there was no down payment. There's no initial payment that it discusses is non-refundable unless the applicants are denied their credit and background check. Your Honor, this is not a normal purchase agreement, and it has no closing date, no nothing on it. My client has rescinded 2 days after he signed it and said he does not want to sell it to her.
And again, my comment on that, Your Honor, would be that my client was prepared to close on it, had coordinated with a lender in order to do so, and he refused to go forward with the closing, and there is no provision in there which allows him to unilaterally rescind it. I think it's also worth noting, Judge, that the parties, and I'm sure Your Honor has put 1 and 2 together, at one point in time dated each other. And one of them was required to leave the premises because of a police report. And so what this appears to be is
oh dear God. Is that true?
Your Honor,
hold on a second. No, I just need a very clear answer because this court has a very clear policy on that. And I'm just going to say, because usually it's the male that's doing this. Is there a domestic violence complaint that was made?
Yes, Your Honor, it was made on October 23rd.
And he was then required to leave the premises?
Correct.
I am not.
And Your Honor, there's no charges pending against my client. In fact, the charges were dismissed by Miss Bailey 2 days later after she made the complaint.
Okay. How long were they living together?
That would be something that my client would have to answer, Your Honor.
Judge,
Miss Bailey, how long?
Living together 1 year.
Okay. All right.
Your Honor, I wanted to add something. I just wanted to say that the reason why of wanting to go back on the purchase agreement was because initially I had signed the purchase agreement, and the next day she was trying to falsely accuse me of, and call the cops on me for stuff that wasn't done, and just falsely accuse me. So that was why.
So you got mad and said, I'm rescinding the purchase agreement, blah, 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 blah. I hear it all. All right. So what do you guys want me to do? I am not issuing a judgment. Not today. And I'm assuming, Mr. Hampton, you want to file a written answer to this.
I do, Your Honor, and I think it would be helpful if the court actually saw the purchase agreement as well as the lease agreement.
Somebody attach it, because if the purchase agreement's there, but there's also another signed document between the parties, correct?
There's a purchase agreement that was signed between the parties, Judge. The other agreement was signed with the park landlord, to which my client is a tenant, as well as Mr. Johnson. They are both tenants from the park landlord standpoint. I will attach both of those to my written answer.
Yeah, that was going to be my next question. So under what theory is the plaintiff terminating the tenancy?
Eviction. He owns the mobile home that she is living in at this time. He owns the mobile home. He actually has a mobile home mortgage that he has to pay every month. On top of that, then they rent the property the mobile home is on. So the only thing they have a lease for is the property that the mobile home is on with that park. So all he has to do, in which he has already started doing, and is he has to go in and get her off the lease, which means he just has to do it.
If I went to a family court and deal with a divorce, that's not really a divorce, I would have done that. I don't know why I'm even dealing with this mess.
Because it's an eviction, Your Honor.
I don't know that it's a proper eviction because I've got a purchase agreement for property that one is saying I got mad and I just rescinded it after I signed it. The other party is saying, well, I'm sitting in here and he's gonna, I mean.
Yeah, the terms of this purchase agreement haven't even been fulfilled by her. She's already, at the beginning, she was supposed to give him initial payment, and that has never been done. So the terms of this purchase agreement are
Yeah,
so
but your
vague.
client just said that's not the reason why he wants to rescind it. He wants to rescind it because he got mad because she was saying things. He just
Your
said
Honor.
that to me.
Yeah,
The-
she has not even made in good faith an attempt to go try to finance this trailer.
My client had it financed, Your Honor, and was prepared to close. And I'm looking at the purchase agreement, and I could be wrong, and I
Here's the
don't
thing.
want to be
Well,
held out.
You
Judge.
can
There's
keep talking.
there's
I don't
nothing
really
in
care.
I was gonna say,
I don't really care because if there's a purchase agreement, you're saying that she's not doing whatever. And okay, fine. But your client just told me that's not the reason why he rescinded. I mean, counsel, I'm just going to let you know, because if there was a domestic violence accusation, this court has been very consistent with its files. With a police report filed, whether it's carried through or not, the court is going to be very reluctant to evict someone who may have been a victim of domestic violence.
I
And
understand.
I'm getting the sense that that's the reason why the purchase agreement didn't go forth. That's the reason why everything is now being sort of couched as this eviction and this is my property.
But Your Honor, this could also be a reason how she gets him out of the home. She knows if she calls the police, makes false allegations, that he has to leave the premises. There's a reason it got dismissed 2 days later.
Well, you said she did it.
Well, she did. She went and, she made the allegations to get him out of the house. When he said, well, I'm not going to sell you this property anymore, then she says, I'm going to go dismiss the charges.
Mr. Hamden, how long do you need to answer?
Monday, Judge.
Pardon?
Monday. I'll get it going over the weekend. I actually had intended to get it going earlier this week, but my judicial secretary called in sick, and everything was fine. I had no problems whatsoever, but I didn't get it done. So.
All right. Defendant to file an answer I'm going to give you a week to get an answer in. You're to file an answer by February 27th, 2026. And then I'll set this for an additional hearing. The way this is out, there's no reason for me to set this on a Friday. Give me a Tuesday that I can hear this.
The first Tuesday would be March 3rd.
March 3rd. I'll set this for, I'll call it a settlement conference. I don't know that that's going to happen. March 3rd, 2026 at 9 a.m. All parties are required to be present in person, including attorneys.
Thank you, Jan.
Thank you.
Thank you, Judge.
Pierce Lake Village Association versus tenant. Don't know what that means. Well, tenant, and then there's James Heaton Trust and Ellen Green Living Trust. Oh boy. Go ahead, state your names, please.
Good afternoon, Your Honor. Lydia Camoro appearing on behalf of Pierce Lake Village, P85454.
Good afternoon, Your Honor. Travis Gagnon, appearing on behalf of defendants. I am co-counsel, though my formal appearance has not appeared, with my co-counsel, Angela Jackson.
Got it. Okay. And this is a termination. Dare I ask, where are we on this?
So my understanding is the initial hearing was on February 13th. My colleague appeared at that. None of the defendants had appeared. Last week, we were scheduled to reappear, and Angela and I stipulated to adjourn it 1 week. So this should be the first hearing on the eviction matter.
Well, there was an initial hearing on the 6th. And then the 13th. I'm not sure what happened. I didn't have a docket the 13th, did I? No, I did have a docket the 13th, and you stipulated to adjourn it.
Oh, yeah.
And that's why we're here today. You're a week off, but I got you. All right. So now where are we on this whole case?
Well, I wasn't aware. Are you representing all defendants now?
I'm going to be representing all defendants, although I will note for the record that Ellen Green Living Trust is not an owner of the property, so an improper defendant in this case. James E. Heaton Trust owns the property, and then there is a tenant living at the property. So at least as to Ellen Green Living Trust, that should not be a defendant in the case.
Your Honor, I believe on the deed, and let me see which exhibit this would be. Yes, if we look at exhibit 1 attached to our complaint, it names it names that it was conveyed and warranted to Ellen Green Trust, which is why we named her.
Whose interest was conveyed?
James E. Heaton Trust was conveyed to the Green Trust and James E. Heaton Trust. So our understanding based on this deed, Your Honor, was that both of the trusts own the property and therefore would be responsible for the money judgment that we are requesting.
My understanding is that, again, this is a tenancy deed. My understanding is that there is not a financial interest from the other trust. I'm happy to file a formal motion, though, as it comes to striking a defendant and attach proofs and evidence in regards to that.
All right. So I'm not, I guess as we sit here right now, I'm not sure that I have the party straight. Because you're claiming that the Green Living Trust is a proper party, you're saying that it's not.
I am saying that it's not a proper party, but I'm appearing on behalf of all of the named defendants at the moment. So
okay,
I am here and everyone is represented.
All right, but we've got to figure that all out.
Yes.
All right, how would you guys like to proceed forward?
I mean, you've seen the complaint here to recovery. My understanding is that there are two complaints that they have. Again, plaintiff here is the HOA. They are not actually the property owner. They are moving for an eviction, but not necessarily possession of the property, since they are not entitled to possession. The owner here, as it goes to damages, the James E. Heaton Trust, they are trying to evict the tenant. The items complained about are...
They requested that the trust evict the tenant?
Your Honor, under the Michigan Condominium Act, specifically MCL 559.212, Section 4, the condominium association has a right to move for eviction if the tenant is.
It may surprise you, I know the law. I asked a question as to whether or not they had asked the owner of the premises to evict the tenant.
Not directly, Your Honor, but they received the bylaw violation letter, which gives them 15 days to cure, and that has not been.
Okay.
Your Honor,
So that's a no?
I'm going to say that's a no, Your Honor. They have not requested eviction. They have stated that there's a damage to the outside door fixed at owner's cost, and they've said that there are multiple noise violations and that they should cure the noise violations. Our position is that the noise violations have been cured. They have not produced any police report that since this time of saying that things should be cured, or their notice to quit, that there have been any additional police reports. And I will note that in the police reports, the police did not actually find any evidence of there being noise violations. They noted that they didn't hear any noise. And there's a declination to prosecute that's in the file that was filed by plaintiff in this case. There's been no, I mean, the complaint frames it as saying there hasn't been a cure because the tenant is still there. There's been no request to evict the tenant. I don't think there's a basis to evict the tenant. And so our position here is that there is not cost owed. There's not a request for a common element to be fixed or anything like that. And there's no, there's no further noise violation. So I think it should be dismissed.
Your Honor, we respectfully disagree. Under the bylaws, there's a specific requirement that there's no noisy activity. And there have been numerous calls to the police department evidencing, and we will bring witnesses at the subsequent hearing, but I wasn't aware that that counsel was representing all of the defendants. In fact, in my communications with Ms. Jackson last Friday, she advised that she did not know whether she would be representing all of the defendants or not, and therefore hadn't contacted me since, nor filed an appearance on behalf of all defendants as of today's date. But we will bring witnesses to testify regarding the noise at the subsequent hearing.
And Your Honor, just to
But is that going to be the basis for determination?
Yes, Your Honor, and that is appropriate under the condominium documents.
But has the noise, these people are going to come forth, say my neighbors are noisy. I'm hearing this noise. Has that been cured?
No, Your Honor, and in fact, it's loud screaming and pounding on the walls. It's not just, some loud music or something of that nature. And this happens throughout the day. And this is a problem that has disrupted the neighboring homes.
This is why normally in these cases, counsel, I realize what the Condominium Act indicates, that usually the owner of the premises is contacted, asked to correct the tenant's behavior and or evict. When they refuse or don't do so, then the homeowners association acts.
Your Honor, they received the same bylaw violation letter, which provides them the opportunity
All right,
to work.
I know you told me this.
Correct.
I do hear, I understand, but okay. I guess we're just gonna go down this road. All right, yeah, go ahead.
Just to contextualize, the tenant who is currently there is a relative of the owner, the trustee of the trust. There's the word that I'm looking for. I don't think that it is necessarily contested that the tenant has dealt with some mental health issues of which the family is trying to provide him services for. To the extent that they are sending cure letters to the owner to correct noise violations. Again, the curage here is any damage that has been reported, which is again just some exterior damage to the door will fix at owner's cost. Noise violations are being addressed for the procurement of treatment. I think what's being asked here is an HOA to throw out somebody with a known mental health issue onto the street because they don't like their neighbor. And frankly, we're ready to contest that.
I don't think I have an answer from you guys yet, right? How long?
No, if you, frankly, I could get it by the end of today, but if you would give me till Monday, I'm happy to file the formal.
Defendants to file answer. I'm going to make it by February 27th, 2026. And then you get that, I guess I'll reset this to the 6th. We have, correct?
You have the 6th, yeah.
Then I'll adjourn this out pending that answer to March 6th, 2026 at 2 p.m.
You're in person with you, Your Honor, correct?
Pardon?
You're in person with you?
Yes. So everybody can see how my joyous day goes. Yes. All right. Thank you.
Thank you, Your Honor.
Court does call the case of Clara Gahan versus Holly Ellison.
Good afternoon, Your Honor. This is Ike Start, student attorney at the University of Michigan, and I'm requesting to appear on behalf of Ms. Ellison pursuant to Michigan Court Rule 8.120 under the supervision of Attorney David Santa Cruz.
Permission to practice is granted.
Thank you.
No,
No, she is unrepresented. She is not present. This is defendant's motion.
yes, this is defendant's motion. But I don't have the plaintiff. So what do you want to do?
If you want to hear the motion, Your Honor, I'm willing to argue it.
I'll hear the motion, but what would you like the court to do? I don't have the other side here.
Yeah, we could go forward with the motion.
All right, go ahead.
So, Your Honor, this case was supposed to be resolved by conditional order of dismissal, which was entered by this court on November 21, 2025, and the relevant terms of that the conditional order of dismissal was that my client, Ms. Ellison, was to vacate the property by the end of the year and also facilitates funding for Ms. Gannon. And then in return, Ms. Gannon was supposed to return Ms. Ellison's security deposit within 30 days of vacating the premises as required by law. So Ms. Ellison vacated the property. That's my client vacated the property on December 5th, 2025. And that 30-day period for plaintiff to return the security deposit ended on January 4, 2026. And we had not received the security deposit by that date. So this motion, we have two claims in this motion. First is that plaintiff violated the conditional order of dismissal. And we had not received the security deposit at the time of filing, but since we have received that security deposit after filing, and so the remedy for the breach of the conditional order was simply to get the amount of the security deposit, which we now have. That being said, we have a second claim, which is that plaintiff violated the Security Deposit Act. MCL 5546132 states that the failure of the landlord to return the tenant's security deposit within 30 days of termination of occupancy makes
Did your client supply notice? Or
yes, Your Honor.
a forwarding address?
Yes, Your Honor. She supplied her forwarding address on the day that she moved out via email. And that I believe that's attached as an exhibit on the motion if you'd like to see that email.
Wouldn't all of the provisions of the Security Deposit Act having been waived if you are placing it in the confines of a conditional order of dismissal?
No, Your Honor. The conditional order of dismissal in no way waived the statutory obligations that would make the plaintiff.
Does it say that in the conditional order of dismissal?
Let me take a look. That's also attached as Exhibit A. Let's see. It certainly gives action to reopen the case and to reinstate the case and for the court to issue a judgment if the terms of this order were not complied with. So I would argue that the conditional order in no way waived. And I would say it's pretty clear from the text that it did not waive the statutory obligations of plaintiff. So continuing on, under MCL 5546113, plaintiff is liable to my client, Ms. Ellison, for double the amount of security deposit retained. And Ms. Ellison,
when was the security deposit returned?
It was after the date of the filing, and this was filed on January 29, 2026. So I think it was shortly thereafter. So end of January, maybe early February. But in the meantime, my client was threatened by her new landlord because she didn't have the money to pay for rent. She was relying on the security deposit to be returned, and so this caused great hardship to her, a fallout with her new landlord, and potential, more litigation, and she was very anxious about being homeless.
Was there more litigation that ensued?
No, Your Honor.
It was just her worry that she would be sued.
That's correct, and Miss Ellison contends that she relied on the fact that Miss Gannon would comply with the law and return her security deposit. So when she moved to the new address, she told her landlord that, I'll have the money by January at the latest, January 4, and then January turned into February. And the landlord, in my understanding, was days away from initiating litigation, and my client was anxious about being homeless again, her and her son. And this was all because Miss Gannon failed to abide by the law. And Miss Ellison contends that she is entitled under the statute, and that's the statute. The purpose of the statute is to protect against this exact thing, which is that a tenant would rely on the word of the landlord, but and then the landlord not following through. And I would just say one more thing is that counsel or myself tried to reach out to Miss Gannon many times. When it came to our part, our obligations under the conditional order dismissal, Miss Gannon was very, very willing to communicate, always answering our calls and emails. But as soon as she got her money and my client moved out of the apartment, it was radio silence from Miss Gannon. I emailed her, I called her, I left her voicemails with nothing in response for over a month. And that caused great hardship to my client. And so my client, Miss Ellison, requests that this court reopens the case because it was previously closed under the conditional order of dismissal, and then award.
But why wouldn't I consider all of the provisions or the provisions of the Security Deposit Act because you'd almost have to reserve that, wouldn't you? Because everything in this conditional order of dismissal circumvents the Security Deposit Act.
No, I don't think so, Your Honor. I think
I know you don't think so, but wouldn't you have to reserve it?
Well,
I mean, give me a reason why you wouldn't have to reserve your rights under the Security Deposit Act. You're altering it. You're altering that statute in the confines of this order. For example, it's 4 days and you limited it to 3 days for the time period at which to do that. There's no provision that's laid out. And also you're saying that she's agreeing just to return the security deposit. Just return the security deposit. All of the provisions that would apply within the Security Deposit Act as to what the landlord could do have been altered.
So, Your Honor, if I may jump in for 1 second here.
No, he's doing just fine losing this by himself. Go ahead.
So I would say that normal practice is if you've got a COD that could take more than 50 whatever days it is to be paid out on, that you have to explicitly waive the law. But without an explicit waiver, it obtains. So that was our approach.
But you changed what's in the statute. It's usually a 4-day period, right, to receive forwarding address.
Well, we just did it faster, but yeah.
But you've altered the statute. By the 3 days. You've also altered the rights of the landlord to do anything, because even as I read the terms of this, irrespective of whether or not there's damage, irrespective of anything, the security deposit is coming back. That's not the way the statute reads. You've altered the statute, but now you want to enforce the the remedy
Your Honor, I
provision
I
that's
didn't
contained in the
take the-
statute. Hmm?
I'm sorry, you're breaking up a little bit, but I don't read the conditional order of dismissal to really do anything other than to benefit the plaintiff. So, and I mean, and the law is the law, and if we gave more grace.
No, the law is the law. And the law says that if she gives that notice, that if the landlord has damages, the landlord can do something. The landlord, with regard to that security deposit, the landlord with this conditional dismissal can do nothing but return that security deposit. You've altered the statute and the remedies provided to each party under the statute, but now want to enforce the other remedy provision within the statute. I don't think that's how it works. If what you wanted is to say that given everything we've done here, that if you don't return it within 30 days, that she'd be entitled to double the amount, then it should have been said, but it's not said.
Understood, Your Honor. I mean, my client left in a timely manner. I mean, the fact if this might be a different case if my client left the place a mess and and there was
but it wouldn't matter.
Damages.
But it wouldn't matter. That's what I'm getting at. It doesn't matter. She could have destroyed the whole thing, but regardless, under the provisions of this conditional order dismissal, that security deposit had to come back, which is not what the statute envisions. You can keep shaking your head, but tell me where I'm wrong.
Well, I don't think that this conditional order of dismissal would force her to return the security deposit even if there was damages. I don't think this conditional order dismissal supersedes the law. That's my contention.
Hold on a second, counsel. How do you read that? Look at your paragraph 7. If the defendant vacates the lease premises timely under the terms of this order, plaintiff shall return the defendant's security deposit in the amount of to defendant's checking account or send it via email by forwarding to the address within 30 days of the date that it vacates. Tell me how what you're proposing could even happen.
Well, under the statute, Your Honor, I don't think that the wording that we use in this conditional order supersedes the law written by the legislature. This was just an agreement to get this case settled. I don't.
Yes, you have, because you already altered it with the 3 days versus 4 days. You already altered it, making it mandatory to return it, irrespective of anything else. There's no exception here. There's nothing. There's no exception that if gas, utilities, or anything else is owed, may not have been in this case, but there's no exception in here that if something else is owed, they could take it out of the security deposit. This security deposit was coming back regardless. And the rest of the rights, this court would rule as to what would pertain under that security deposit were not retained or preserved or reserved. And so therefore, your motion to do that, I don't think is equitable and fair under the circumstances, and the court does not believe that that is the intent of the order that I signed. And so therefore, your request for relief is denied.
All right. Thank you, Your Honor.
Thank you. That's all I had on it.
Yes.
Right now. HP Foreclosure Solutions versus All Occupant.
Good afternoon to you and your staff, Judge Simpson. Attorney Paul Spaniello, P72366 on behalf of the plaintiff.
Any occupants?
I'm here. I'm sorry. I'm trying to unmute sorry. Mary Cheatham.
Okay, gotcha.
Okay.
All right, this is a termination. This is a motion.
This is Cheatham's motion to set aside a default, Judge, for what it's worth.
Did you get a copy of it, counsel?
I had to ask the court clerk, and they were gracious enough to email me a copy. Yes, I did.
All right, very good.
Thank you for asking.
Ma'am, what is your position on why I should set aside this termination?
I did not see the court document to come to the, what am I saying? Okay, so I did not receive in the mail the court date until like 3 days after the court date.
Okay, let me explain a couple things.
Okay.
There are two parts to that you would have to show this court.
Okay.
For the court to set this aside.
Okay.
All right. The first part of it being that you'd have to show good cause for your failure to appear, which I think you were going to get into. Okay. What I think is more problematic, I think, for you is you have to show this court that there's a meritorious defense to the claim of determination.
Okay. So I had entered into a lease with them. There was some problems with the payment. I think I addressed that in my motion. I have been in contact a little bit with, I believe her name is Michelle from HP. And I believe that we could possibly come to an agreement to allow me to just extend my stay a little bit so that I can get everything out of here. I guess.
Who did you lease from?
HP foreclosures.
Is that right, counsel?
Your Honor, during the course of the suit, and I do have Ms. Shifter here if you'd like to take testimony, but Ms. Shifter attempted to work out a resolution with Ms. Cheatham to keep her in the property. There was an agreement that if a security deposit was tendered in first month's rent, that they would have this binding lease and that we would ultimately dismiss the case. As you'll see in Ms. Cheatham's unsworn narrative, I guess her money, her husband or spouse absconded with the money, so nothing came of it. My client had attempted to reach out to her on multiple occasions and was largely ignored, and we proceeded. So, effectively, there is no lease, albeit, we tried to work something out with her, but if I can finish.
Sorry.
This case was filed on December 9th. The redemption, I don't have it in front of me, expired late last year. And now we're here on February 20th, Your Honor. And there's still been no monies produced. So it's our opinion that there is no lease agreement. I mean, my client would not enter into a lease without that.
But I guess, was there signed documents of a lease?
It's my understanding my client did sign the lease, but predicated that the effectiveness of the lease on that payment.
Okay. So I don't have a copy of the lease.
Well, it wasn't a part of this action. It was something that occurred, my understanding, during the course of this matter. When I appeared at the first hearing, I was hopeful, and I even may have put it on the record that the parties.
Well, counsel, here's the problem with that argument. Under paragraph 5F, this action was maintained because of the expiration of the redemption period, but then specifically indicates no tenancy.
Correct, and there was none at the time that the matter was filed, Judge. I'm sure Ms. Cheatham will tell you, and my client representative will tell you, that after this was filed, they were trying to work out a resolution to keep Ms. Cheatham in the.
But then we get into the other issue. So you're saying this signed document, this lease, was entered into after this case was filed?
That's my understanding, yes, Judge.
Ma'am, is that correct, Ms. Cheatham?
Yes, if they filed it on December 9th, because I don't.
When did you sign the lease?
I did, sir. I did, Your Honor.
No,
and I am
when?
prepared.
When?
Oh, when? It was in January. I don't know the exact date. Might have been like the 9th or something. I'm not quite sure. But I am prepared to. I have the money to pay them at least the $3,800 today.
Hold on.
Okay.
Hold on. Stop.
Okay. Okay.
So after this action, both parties signed a document purporting to be a lease. I don't know how there is a conditional lease, but I guess that's what counsel is saying. And Ms. Cheatham is saying that there's a lease. I don't think, counsel, you can argue that there's no lease if both parties sign this document. I don't know how that works.
Well, if I may, just for purpose of nothing else, Your Honor, making a record, there's no consideration. I mean, my client could sign a lease, and if it's predicated, it's our position, it's predicated on payment, like most leases are. And if no security deposit was tendered, no first month, effectively, there's no lease.
No, that's not how tenancy works. I mean, if she's in the premises, you're in the premises, ma'am?
I am, Your Honor.
She'd been in the premises during the whole redemption period, my
I
understanding.
have not. I was in a halfway house. I just got released on January 30th.
Well, we were here before your January 3rd. We were here on January 9th, Your Honor. It was the first hearing, I believe.
Because I'm the executor of the will, so I've been like appearing for court hearings and things like that. But I've been pretty upfront about that. Like when I first came into contact with HP Foreclosure Solutions, that I had just been released from incarceration last July, and I've been in the halfway house since.
Okay, so who's going to send me a copy of this lease or this conditional lease or this thing that one side is purporting not to be a lease, but the other side is saying it's a lease? Because I don't even know how I begin to rule on this without a copy of it.
I don't have a copy. Ms. Cheatham or my client's representative, Ms. Shifter, I could have Ms. Shifter send me a copy and I could forward it to the court via email, or Ms. Cheatham, I guess, could. I'm sorry, I don't have a copy.
If I may, I'm sending that right now.
Okay.
Michelle Shifter.
I'm sorry, Your Honor.
Let me pass this matter.
Okay, thank you. And
then it
then
needs to be sent to my staff.
may I have the staff, can somebody put the staff's email in the chat if they don't mind?
She is putting it in there now.
I appreciate it.
Court recalls HP foreclosures versus all occupants.
Paul Spaniel, Your Honor, on behalf of the plaintiff.
Mary Cheatham.
Counsel, how are you? I don't know how I get to the point of you saying when I'm looking at this that this is not a lease. Parties have all signed this, right?
Correct, Judge. As what was sent to me, I reviewed it in anticipation of us going back on the record. It does appear that it's signed. Other than the consideration provided by Ms. Cheatham, before you as well.
The problem I've got here is that I don't think, quite frankly, that, well, I'll just say it this way, that defendant has a valid lease. And I would submit to you that the beginning of this case, because of that, this court doesn't have jurisdiction to hear this case. I won't have subject matter jurisdiction under the theory on which this case has been filed, because you filed it because of the expiration of the redemption period, but at some point a new lease entered in or new interest in property entered in, which I can see. So I don't think, there may be other reasons or a basis upon which this case could then proceed, but I can't proceed as is. I don't think the court has subject matter jurisdiction. When I don't have subject matter jurisdiction over the case, then the only thing I can do is dismiss it.
I anticipated that, Judge Simpson, and I appreciate that. Would you just be inclined to dismiss it without prejudice, and we'll send out the appropriate notices today and get the ball rolling on an appropriate matter before you.
All right, very good. So, like, so that dismissal is without prejudice.
And respectfully, thank you for entertaining my argument. I appreciate it.
Not a problem, sir. All
Take
right,
care,
thank
Your Honor.
you.
You and your staff have a great weekend.
You do the same. You also, Ms. Cheatham.
Thank you, Your Honor. You have a good day.
Oh, in the Nisqually Jail, City of Olympia, your name, please?
Al-Orabi Abdulaziz.
Thank you.
Welcome.
And is the last name Al-Arabi or the last name Abdulaziz?
My last name is Al-Orabi. Al-Orabi. B as in boy, I as international. A is I will repeat that. A as in apple. L as limbo. O as Oscar. A as in apple. B as in boy. I as in India. That's my last name. That's my short name. Basically,
all right.
My my permanent resident, not green, not marijuana green card.
Okay, thank you very much.
Thank you, Honor.
All right, Mr. Wicks, you've indicated you have a difficult time communicating with Mr. Al-Arabi.
That's correct, Your Honor, and I'm fairly certain it doesn't simply relate to language. So I think it makes sense at this point to do an evaluation pursuant to RCW Title 10, Chapter 77.
Okay, you'll find that we're hesitant to do that for obvious reason, which is Western State is so backlogged. Putting a case into that system right now is not a very efficient way of dealing with what may just be other issues. So I'm going to run through
I understand that, Your Honor, but I do feel that I need to raise this.
Yeah.
Your Honor,
I'm not saying you shouldn't raise it, but I'm going to do a little inquiry of my own here.
And Your Honor, may I give the court a little bit of background about this defendant to clarify? He has been he's never displayed incompetency concerns before in his many cases. Mr. Al-Arabi is a pretty severe drug addict, and he was caught with fentanyl this time. He has previously, when he's been in court, displayed symptoms of being intoxicated or coming off of his substance. And so he sometimes presents a little odd at his first appearance. So I would ask that the court not enter its 1077 today after its finding, and set this over for Monday so we can give him a bit of time to basically sober up.
All right. So Mr. Al-Arabi, as Mr. Carver, the prosecutor of the City of Olympia, indicates, you've been charged with possession of controlled substance. It sounds like it's fentanyl is the allegation. Do you know what your constitutional rights are?
No,
Mr. Al-Arabi?
No, I was when they came to me, when the city police came to me, I was around my property and.
Sir, don't talk about the facts. He's just asking if you understand your rights.
And Mr. Wicks is doing his job for you. So you don't want to say anything about the charge because it could be used against you. I just want to make sure you understand what we're doing here today.
I thought it's just a bench warrant of my arrest, or I'm not in Thurston County. I'm here in Nisqually.
Right. Well, that's in Thurston County, but yes, it is a bench warrant because you missed a hearing on the 9th of February. And so because you missed that hearing, I ordered a warrant for your arrest and you got arrested and you're here now. Do you understand that?
I went to, I believe the same day I went to Thurston County and they gave me a piece of paper, said I have to show again in the 20th.
Yep. I see that you showed up later that day after the hearing. I do see that.
After the hearing, you're right, and I wasn't there, and they gave me a piece of paper to come back again, and before I came back, I got arrested yesterday,
Okay.
about more than 24 hours ago.
Got it. Thank you.
You're welcome.
All right. Probable cause was established on that date on that charge. I'll enter a not guilty plea for Mr. Al-Arabi. And Mr. Al-Arabi, do you work?
I used to, yeah.
Okay. And you're not working now because why?
I got arrested a few times. I was in Esquali before for more than 3 months.
Right. Okay. And Mr. Al-Arabi, you understand you have the right to a jury trial on the charge against you? You understand that?
I don't understand that, no.
You don't understand?
You said, I don't understand the jury trial.
Okay.
Your Honor, and this is exactly what I was talking about. I don't think
okay. All right. I gotcha. Yeah, I'm not saying competency issues. I don't think it's that.
May I suggest
well, we have lots of warrant history here, no active warrants currently, but based on the failure to appear a number of times on past cases, I will hold Mr. Al-Arabi until we can continue the arraignment hearing where counsel will have an opportunity to have a discussion with Mr. Al-Arabi about his rights to confirm that he understands them. And I'll hold Mr. Al-Arabi on $1,000 cash or bond and set a hearing.
Your Honor, I renew my request for a 1077 evaluation. I understand the court is frustrated with how long it takes Western. Lord knows I am too. I believe it is necessary in this case, having spoken to him privately.
Okay, yeah, but right now I'm going to disagree with you, Mr. Wicks, and we're going to set for hearing.
And Your
next
Honor,
week.
He's denied this in the past, but I was going to suggest that he be set on an interpreter calendar matter, and if we could just confirm either through his assigned counsel or another arraignment counsel that he does have a thorough grasp of the English language.
Yeah. Okay. And the language is Greek, is that right, Mr. Al-Arabi, or something else?
I speak Arabic.
Arabic? Okay.
Arabic, yeah, I speak Arabic and English. Like where I was born in Kingdom of Saudi Arabia.
Yeah. Okay.
The country of birth is Saudi Arabia.
Okay. Thank
Saudi
you.
Arabia, SAUDI.
Yeah. No, I got it.
All right.
And City of Olympia interpreter cases are going on what calendar, Mr. Carver?
I believe those are Monday mornings, and that'll be me this Monday. 10:30 on Mondays.
Yeah, it's
Your Honor, my
too,
concern is that I'm coverage
Mr.
counsel for that. I don't take permanent cases for the City of Olympia. I'm a docket coverage guy, and I'm going to be covering that docket. I think at this point, at the very least, we should.
I'm not going to put it on that docket because we're not going to have time to get an Arabic interpreter present for that court date. I think I'll probably set it out to the following week, the 2nd of March. And what do we have a designated time for interpreter cases for the City of Olympia? Okay, it'll be set for 10:30 on the 2nd of March, and I suspect you're going to tell me you're the coverage calendar on that one too, but this will give you more time to speak to Mr. Al-Arabi and
Well, Your Honor, in
You know,
that
what
case,
you
I'd
have
ask
in the
the
1077 request, Mr. Wicks, in my mind, isn't sufficient factual basis for me to order that. So you need a more detailed conversation with him. Mr. Carver suggested perhaps after he's in custody a little bit, it might be more clarity. Regardless, we'll have a hearing on the 2nd of March. I'll list it as an arraignment just so we can make sure that Mr. Al-Arabi understands his rights. But I want to make a record that I intend to start speedy trial from today's date.
Understood,
Right.
Your Honor. I would ask the court appoint permanent counsel. I don't take individual case assignments for the city. Typically, I tip docket coverage. So I'd ask the court to assign someone.
It'll be an arraignment just like today, right? But with an interpreter. So how is that different from how you would normally appear?
It's not so. Just typically.
Hey, gentlemen, we have a really busy calendar today, so we're just going to move through these cases. And given, we're going to continue this. I will appoint counsel to represent Mr. Al-Arabi, whether Ms. Whaley wants to designate Mr. Wicks to handle it since it's on his coverage calendar, or she wants to have coverage counsel there, that's up to her. But I will appoint counsel to represent Mr. Al-Arabi.
Thank you, Your Honor.
All right. Thank you. Thank you, Mr. Al-Arabi. We'll see you on that date.
So when I'm supposed to be, when I'm supposed to see you again?
A week from Monday, so the 2nd of March.
10 days or more than 10 days, actually.
Yeah. Okay.
All
right. We'll see you then.
So I'm not guilty, right?
You've not been found guilty of anything, but I found probable cause, or somebody previously found probable cause on this charge. So, okay. Thank you, Mr. Al-Arabi.
All right. See you later. Thank you.
Yep. Bye-bye. Sounds very competent to me, frankly.
Well, what do you think? Does he sound competent to you? Or is it really a mutually exclusive proposition? Maybe it's a little bit of both. Maybe he is a little bit bad at the English, and also oh my goodness, I don't know what I'm doing anymore. Lord have mercy. It's all wrong. It's all wrong. Ladies and gentlemen, thank you so much for hanging out with me tonight. It's been a great show. I hope you enjoyed it. These were just some of the interesting things I found from around the court sphere on YouTube today. Some of these cases, when I was listening to them today, just made me cringe. Some of them, I don't even know. I don't know what to tell you. Look, I'm going to send you over to Hutch. He's got something going on. But first, I want to say thank you very much to Jermurger and Sovereign Legal Encounters. Thank you guys so much for hanging out. We got a live coming up in just a few hours at noon Eastern Time, 11 a.m. Central Time. Weekend review should be good this week, ladies and gentlemen. Come on by and hang out with me. I am your Lone Wolf Usul. And for now, ladies and gentlemen, I am out. I'm sure I forgot to say a whole lot, but it's one of those nights, ladies and gentlemen. Just flabbergasted. Listen to the music. Chill out. See you next time.